Hello. Ladies and gentlemen, we thank you for attending this event today. Justice Buergenthal will be out shortly. In just another minute or so, we ask you at this time if you could turn off your cell phones, if you could prepare to listen to a thrilling event, and also if you could just remember to stay for the full event. Thank you very much. We'll just get started in another minute or so.
Good morning. I'm Joyce McConnell, the Dean at West Virginia University College of Law. Welcome to the College of Law this morning. We are a public law school within a large public research university, both of which are committed deeply to global initiatives, particularly international human rights. When I arrived here 13 years ago, former Dean and Professor Carl Selinger and Professor Jim Friedberg were actively engaged in the long-term pursuit of establishing the College of Law as a center for international law and human rights. 13 years later, today, the fruits of their labor are evident in the number of our faculty involved in international human rights work and scholarship, in the vibrant exchange programs we have in Brazil, France, and Mexico, in the eagerness of our wonderful students to participate in all things international, including trips to Brazil and Mexico, the Jessup Cup International Law Moot Court Competition, the Clinton Global Initiative. 4 of our students just returned from the Global Initiative, and our own International Law Student Association. Today, we are deeply indebted to the Shergott Foundation, and particularly Mr. William J. Butler, the president of the foundation. With Mr. Butler's contributions spanning over a half a century, his name is truly synonymous with civil liberties and human rights. His accomplishments are staggering. While he's best known for his long association with the International Commission of Jurists, where he has served as the chairman and the president of the American Association, early in his career, he argued and won 2 landmark civil rights cases in the United States Supreme Court, namely Engel versus Vitale, 1962, what you might know as the school prayer case, and Kent versus Dulles, 1958, the passport case. He's the founder of the Urban Morgan Institute for Human Rights at the University of Cincinnati College of Law and currently serves as its chairman. We thank Mr. Butler today for providing us this opportunity to host the most honorable Judge Thomas Buergenthal, the United States Judge on the International Court of Justice, and to hear Judge Buergenthal's lecture today, International Courts, How They Work and Why They Matter. We are honored to welcome Mr. Butler and Judge Buergenthal here today, along with Mr. Butler's daughter, Ms. Patricia Ramirez, and her fiancé, John Whitehill. In addition, I am delighted that we can host special guests, Chief Justice Brent Benjamin of the West Virginia Supreme Court of Appeals, and Ms. Tori Herring-Smith, President of Washington and Jefferson College. In addition, I understand that there are representatives here from Bethany College, which is Judge Buergenthal's West Virginia alma mater. Mr. Butler and Judge Buergenthal have invested their lives to protect the human rights of the oppressed, disempowered, tortured. They have been the voices of those for those who cannot lift up their own, who cannot be heard by the world. Mr. Butler and Judge Buergenthal give voice to all of those whose voices are often silenced. Mr. Butler and Judge Buergenthal know each other from their work on international human rights issues, including their shared association with the International Commission of Jurists. It is a great honor for West Virginia University College of Law to host the Shergott Lecture and Mr. Butler and Judge Buergenthal. Because of their commitment to us, we are able to continue our commitment to providing a forum for deep intellectual engagement around issues of discrimination and power. We take a stand on tough issues, such as human rights, bringing it out in the open and making it the subject of a lecture, such as Judge Buergenthal's today. Proof that our law school is a step ahead of traditional thinking and willing to push boundaries of understanding through education. For this opportunity, we once again thank the Shergott Foundation, President Butler, Professor James Friedberg, and David Foreman of the West Virginia University Foundation. Welcome, everyone.
Hi, I'm Professor Jim Friedberg, and I'm happy that all of you have been able to come today to this wonderful event. Before I tell you a little bit more about Judge Buergenthal, I wanted to give his alma mater, Bethany College, a chance to say a few words. And we have the chair of the History and Poli-Sci Department from Bethany, Clint Moffitt. Sorry about that. Okay. To tell you about one of Judge Buergenthal's many fascinating periods of sojourn, that in West Virginia.
Good morning, everybody, and what a special day. I was asked to come and give a special message. At least that's what the brochure states, but I'm not so sure that anything I have to say today is as special as our distinguished alumni, Judge Buergenthal. I was talking to the judge a few minutes ago in his chambers, and I got a little chuckle out of the fact that when he applied to Bethany, he thought it was a Christian school, and he didn't know if he would be accepted. And on his way to Bethany, he took the train to Pittsburgh and then to Wellsburg and then on to Bethany, and he expected to see Indians, I believe. But he also told me that there were many students from the East Coast at Bethany at that time. I have come to extend greetings on behalf of President Scott Miller of Bethany College, the faculty, and students. We are very, very proud to claim this distinguished man as an alumni. 15 students from Bethany have come with me today, and I must say that when I asked them to come, it took them all of about 5 seconds to volunteer, and we really brought about as many as we possibly could. I'm also proud to say that I think there are 7 Bethanians here at the law school right now, 4 of whom I see. I hope the others are here as well. Some of you have read the brochure and perhaps know a little bit about Judge Buergenthal's experiences. But maybe many of you don't know that he is an alumni of Bethany, having graduated summa cum laude in 1957. He went on to study at New York University and Harvard Law School, and as he told me earlier today, he always had an interest in international law. It was something that I guess sprung out of his own life story. We at Bethany but we remember those dark years in the 1920s and 1930s in Europe. We have a series of lecturers that come to Bethany and speak to that episode, and we hope that someday Judge Buergenthal can come and speak as well. He also graduated from Bethany and received the Orient E. Scott Award, which is the highest honor that we can give to a student. It is the student with the highest academic standing. He's distinguished himself with a record of service to education, both as a dean and as a professor. We all know that he's one of the most respected international scholars in the area of human rights. His eyewitness accounts of those terrible, terrible days, as we know, have motivated him to spend his whole life educating and reminding students, new generation after new generation, of what we have to do to prevent those types of things from happening again. He's devoted his life to encouraging people to stand up and fight for their rights, fight for their human rights, fight for their justice, and most importantly, fight for their dignity. And we are very, very, very proud to claim him as one of our alumni. If you read our alma mater, our song, the alma mater, it says, "High up on the roll of honor and fame, my sons and daughters have written thy name." And certainly Judge Thomas Buergenthal has brought honor and fame to his alma mater through 50 years of commitment to education and human rights. and justice. And on behalf of the Bethany community, I just want to say thank you very, very much, and a job well done. Thank you.
Thank you, Clint. I will try to limit my remarks introducing the judge because I know you want to hear him and not me. But there is so much to say, it's going to take a couple of minutes. We are at an era of change in our country, as all of you who have been awake for the last 6 months know. And hopefully, one of the central elements of that change is going to be an increased respect for the rules of the international community. Rules that the United States has not always followed in the last decade. Judge Buergenthal and his court are at the center of the battle over whether we will be a nation that observes the international rule of law or not. For example, one of the most recent cases that has come before the World Court has been one in which Mexico sued the United States for our failure to observe international law by letting prisoners in American jails have the access to their consular officials' advice that they are entitled to under a treaty that the United States has been a party to for many, many years. Other issues that come to mind have to do with detention of prisoners, invasion of foreign countries. All of these are international law issues, and certainly not all of them will get before the World Court. But adherence to the World Court's opinions and respect for it as an institution are part and parcel of the reform of the mentality in this country that we hope is in the works in the next few years. Judge Buergenthal is one of the stalwarts of the mentality of a global respect for rules, rules that make everybody hopefully safer and happier and freer from fear. This obviously reflects Judge Buergenthal's background as a Holocaust victim, as an excellent scholar in the areas of international law and human rights, as a judge on numerous courts, including being the first and only U.S. judge on the Inter-American Court of Human Rights. Now, for those of you that don't study inter-American human rights, you might miss the irony here. The United States has not adhered to the convention establishing the Inter-American Human Rights Court in Costa Rica. Therefore, one wouldn't expect an American judge to be sitting on that court. We don't have a right to appoint one because we have not, as most of the rest of the hemisphere has, adhered to the treaty. But Judge Buergenthal was a human rights scholar and activist of such respect that he was nominated by Costa Rica to be its representative on the first sitting of the Inter-American Court, a position he held for numerous years. He has been on the World Court, the International Court of Justice, the premier court of the international community, the judicial arm of the United Nations, for almost a decade, since he was appointed by President Clinton in the year 2000. He was reappointed, I misspoke there. We don't appoint the U.S. judge on the World Court. It's a matter of informal custom that our government has the discretion to suggest to the parties involved, ultimately the General Assembly and the Security Council, please approve this person that we think is qualified. So he was suggested by the Clinton administration and approved. Inadvertently, apparently, in reappointment in 2005, the Bush administration failed to submit a different name, and he is still on the court. he has indicated to me that this may or may not have been a oversight by certain persons within that administration. But happily, he has stayed on the court and has served it well and served the global community well in the same way that he served the many universities, George Washington, University of Texas, SUNY Buffalo, at which he taught well. So without further wasting your time by citing a long, long, long resume for the judge, I would rather let him talk, and I give you Judge Thomas Buergenthal.
I think the best I can do after this standing applause is just to sit down. Thank you very much for this very generous and kind introduction. Thank you, Dean, also. It's a great pleasure for me to be back here, and it's wonderful to see Bill Butler here. I can't refer to you as President Butler, but Bill Butler is somebody I've known longer. Well, I've known before I even got into human rights, when he was already working in the field. It's wonderful to be back in West Virginia. As you heard, my connection to West Virginia, as has been pointed out, this was the only college that was willing to give me a scholarship, because by the time I applied to college, I'd only had 4 years of high school, and any sort of grade school and college education. I mean, high school education. And Bethany was willing to take a chance. So I have special gratitude, eternal gratitude to Bethany. And I've got an extremely good education at Bethany. And I was so delighted to see the Bethany students and professors here. It means a great deal to me. I should also say that it was in West Virginia that I became an American citizen, which again, meant so much to me. Even the FBI hurried up to allow me to get the citizenship, because Bethany had nominated me for the Rhodes Scholarship before I was a citizen, and so I had to move. And the FBI in 2 weeks cleared me, so it was wonderful. Since then, they've regretted it, I'm sure. So it's wonderful to be here. I've never been in Morgantown, but I hope to be able to come back if one gets this big an audience. It's wonderful. I thought what I would do is just give you, I was given a wonderful title by Professor Friedberg, which I liked very much, and then I had to figure out how to work around this title, which was International Courts, How They Work, Why They Matter. So at the end of this, you can decide whether I complied with the mandate or not. But I thought I would just give you a brief overview of what international courts we have, and then take your questions. It's much better to work that way. So let me begin by noting that we have an ever-increasing number of international courts, both universal, what I would call universal courts, and regional courts. The universal courts are those that are open to memberships by all states that are members of the United Nations, and sometimes even others that are not. Now, what accounts for this development, this tremendous almost proliferation or explosion of international courts? The short answer really is that the international community needs such courts, because the world has become ever more interdependent when it comes to trade, communications, travel, crime, even domestic relations. It's interesting to see how many domestic relations issues now come up every day, that even though they are governed by private law, conflicts of law, they are international in the sense that they're also governed by relevant treaties on the international plane. Now, as I was rereading my talk, I was thinking whether, given the current economic situation, whether in fact one could argue that if one could show that one country was responsible for all of the problems we have at this moment, whether that country in some way, say by not regulating, committed violations of international law. The interdependence. Of course, I don't think one can prove that one country is necessarily responsible. But sooner or later, we're going to be dealing with situations very much of this nature because everything is so interrelated today in terms of all of these activities that we engage in. Now, the interdependence, of course, has the consequence that many disputes arise today that have these international dimensions in the sense that they call for the application of international law and for the adjudication by international tribunals. In short, these are not disputes that can be settled satisfactorily by national courts, and if they're not settled on the international plane, they tend to create friction between states and sometimes even serious political conflicts. Now today, there exist two types of international courts. As I mentioned, first is the universal ones, and of these, the universal, these are the courts that are open to all nations. And in this group, you have first the International Court of Justice, on which I sit. It is the principal judicial organ of the United Nations and considered to be, as was mentioned, the highest international court. And of course, those of us who sit on it, we all think it's the greatest ever, but there are other equally important courts. But don't tell that to my colleagues. Now, the ICJ deals with disputes between nation states. In other words, individuals and corporations don't have standing to appear before us. On the other hand, quite a number of disputes that we hear originated in problems that individuals have with other countries. So while the individuals cannot bring a case to us, the cases that come often raise issues that involve private individuals. Now, we have recently decided disputes concerning territorial and maritime delimitation. That is to say, what's happening in the world today is that many countries suddenly realize that the ocean is a tremendous economic asset and that there are some little islands that they didn't even know existed are very important because with them come oil and gas resources. And suddenly, my court has been flooded with these claims, where various countries claim that they have rights in little islands that are rocks that they never knew existed. And these cases come to us, and we call that delimitation. We have to decide who is entitled to what on the high seas. We've got quite a number of cases. Just before I left The Hague, we decided a dispute between Romania and the Ukraine in the Black Sea. And there's a little island called Serpent's Island that nobody knew existed really, that had any significance. Suddenly Serpent's Island became occupied. 17 judges on my court. We are 15 judges, but both countries, if they don't have a judge on the court, can name another judge of their nationality or another nationality. So 17 judges worrying about this little Serpent's Island that was claimed was never inhabited until the Ukrainians decided to put some buildings on it to show that it was really an inhabited island. So those are some of the things we do in that area. We deal with the use of force, quite a number of cases relating to the use of force. One of the more recent ones between the Congo and Uganda. Human rights and humanitarian law, we had a big case that the court decided I recuse myself from the case between Bosnia-Herzegovina and Serbia. It was a genocide case. Illegal exploitation of natural resources, another case. Environmental law. We now have a case that Ecuador has brought against Colombia, claiming that the spraying of marijuana and other plants comes over to Ecuador and destroys their agriculture. So this is one of the cases we have. We have another case between Argentina and Uruguay because Argentina claims that the paper mill that is being constructed on the Uruguayan side of the river Uruguay is polluting the water of the river, And so we're getting those type of cases. Cases also involving diplomatic and other immunities are coming to us. Cases that I never thought would come to us. For example, recently a case involving a lawsuit by Germany against Italy, claiming that an attempt by Italian courts to confiscate certain property belonging to Germany because of claims against Germany for war crimes committed during the Second World War violated the immunity of the German government. That's a case I never thought I would see, given how much time has come. Well, that's what we do sitting around in The Hague, which is incidentally a very pleasant place. The Hague is known today, and the Dutch are very proud of it, justly so, as the judicial capital of the world. We actually have 4 international courts sitting in the Hague. And so there are more judges there, as I pointed out the other, probably than lawyers in Washington, D.C. or psychiatrists. We don't have many psychiatrists, and sometimes sitting on my court, I feel we do need them. The next court of a universal character is the International Criminal Court, and also the next one is the UN Law of the Sea Tribunal. Both of these are universal courts in the sense that any state can join them. Unlike the ICJ, the International Court of Justice, the International Criminal Court and the Law of the Sea Tribunal are relatively new courts. And the ICC, as you know, is just beginning to work. You may have read just a few days ago that the ICC, the International Criminal Court, has decided to indict the president of the Sudan on charges of genocide, crimes against humanity, and war crimes relating to the Darfur situation. There is, and those are the crimes really that the International Criminal Court will deal with. Some of us have waited 60 years for an International Criminal Court to come to be established after Nuremberg. It's finally here. It's very sad that the United States is not a party to this court. There is also the appellate body of the World Trade Organization that in some ways is a universal court. The U.S. incidentally is a party to that court. Now, in addition to these universal courts, there now exists an ever-growing number of regional courts. And these regional courts, there are 2 types. One are the human rights courts, the regional human rights courts, and the other are the economic regional courts that deal with economic and trade matters. Now, the human rights courts, we have 3 regional human rights courts: the European Court of Justice, the Inter-American Court of Human Rights, on which you heard I sat for 12 years, and the African Court of Human and People's Rights. I should tell you the story about how I got on the Inter-American Court, at least part of the story. I was teaching at the University of Texas at the time, and I had a seminar on human rights. And I would tell my students in this seminar, when we dealt with the American Convention on Human Rights, as Professor Friedberg pointed out, that no American would ever sit on that court because the U.S. hadn't ratified. And then I received a telephone call, and somebody with a deep, sort of thick Latin American accent that I thought was put on said that his government would be honored if I accepted the nomination to the Inter-American Court of Human Rights. I was sure that it was one of my students in my class. So I asked the supposed ambassador for his telephone number. And sure enough, it was the telephone of the Costa Rican embassy, and that's how I got on the court. And it was probably one of the greatest experiences I had, because it was the first, the 7 judges who were elected, we composed the first court, the Inter-American Court. And it's wonderful to be able to do the work of a John Marshall, at least thinking that that's what we were doing. Well, in addition to the European Court and the Inter-American Court, there's also an African Court of Human and People's Rights. The oldest of these courts is the European Court of Human Rights, which incidentally is this year celebrating its 50th anniversary. And the other two courts are modeled, in turn, on the European Court. The Inter-American Court, to which I was elected, was established in 1979, whereas the African Court was only recently established and is not really, as yet, unfortunately, fully operational. Now, the conventions establishing the European and Inter-American courts allow individuals who have been denied their human rights, the human rights that are guaranteed in these treaties, to appeal to these courts, provided that they have exhausted their domestic remedies. So there's usually a procedure where you cannot just go to the court. You have to first try to get justice done in your own country. Now, these regional courts have the power to order a country, and incidentally, even though it's, say, the European Court of Human Rights, an American who is a victim of a violation of a human right guaranteed in the European Convention of Human Rights, committed by a member of the European Convention, has the same right to sue in the European Court as anybody else. So it's an important, this universalizes, in a sense, the protection of human rights for countries. They can award damages. They've done that. The European Court has done so on many, many occasions, can order measures to be taken to remedy the situation, and also measures to be taken to change domestic legislation. And on the whole, with the exception now of some of the new countries coming in, the awards have been complied with fully. There are problems with some of the new countries because now the European Court of Human Rights has really become the Supreme Court of Europe as far as civil liberties are concerned. But there are still problems with some of the Eastern European countries, particularly when it comes with compliance by some of the big countries. Now, to those of us like Bill Butler and me, the establishment of the human rights courts is really a dramatic development in international law. It's something that our fathers would never have believed possible. I've argued that if such courts had existed in the 30s, that maybe some of the things that happened could have been prevented. So these are important developments, and our job now should be to encourage other regions in the world to establish similar courts. Unfortunately, they're only in 3 regions, and for the moment, only 2 of them are working effectively. Now, I'd mentioned before that the other type of regional courts that we have deal with trade matters. And here you have the most important one is the European Court of Justice. This is the highest court of the European Union, a court that now has jurisdiction as far as economic and trade matters are concerned over 27 European countries, and all of the major, really, economies of, particularly of Western Europe at this point, but will probably be expanded. Incidentally, you may have read from time to time that American corporations which do business in the European Union are also subject to the jurisdiction of the European Court. And for example, Microsoft has had real problems and been paying some very high fines for violating antitrust regulations of the European Union. So when I talk about the interdependence of the world, it isn't just a cliche, it is a reality that we all have to recognize. And if you're in business, and not just human rights, but all activities, it's all interwoven today in the world in which we live, which shows how important international courts are. Now, a number of other regions of the world have established similar type of courts, like the Court of Justice of the European Union. So you have the Andean Court, Common Market Court, which is in Latin America. You have a few of them coming up in Africa. I've lost track of the ones in Africa, but some of them work quite effectively in the economic sphere. And I think more of these courts are going to be established in other regions of the world. They're really quite important, particularly the regional trade courts. Now, in addition to the permanent regional courts and permanent courts in general. The United Nations has in recent years established a number of ad hoc international criminal tribunals. For example, and to deal with international crimes that have been committed. Well, you might ask, why do we need these ad hoc tribunals when we have the International Criminal Court? And the answer to this question is that these ad hoc tribunals deal with crimes that were committed before the International Criminal Court was established, or crimes over which the International Criminal Court does not at this point have jurisdiction. So you have, for example, the International Tribunal for the International Criminal Tribunal for Rwanda, the International Criminal Tribunal for the former Yugoslavia. That tribunal, the Yugoslav tribunal, also sits in The Hague. You probably have heard that this was the tribunal where former President Milosevic was tried. He decided not to finish the game, and he died before he was convicted. But currently, the Serb leader Karadzic is currently being tried in that court, and many other former, both on the Serb side and on the Croat side and on the Bosnian side, people who committed criminal offenses during the Balkan conflict are being tried in the Yugoslav tribunal. They're still waiting for one of the generals who was probably most responsible for the terrible genocide that was committed in Srebrenica to be caught. But they expect that that tribunal will be over in 2 years. Now, my own sense, incidentally, is that we probably, in addition to the International Criminal Court, that is a universal court, we probably need some regional international permanent criminal courts to deal, and I have a feeling that sooner or later we're going to decide that we need that, but for the time being, I'm one of the few people who's arguing that point, but I think we're going to see that the International Criminal Court is not going to be able to, and doesn't have jurisdiction over many contemporary criminal issues that are of concern to smaller countries that they cannot deal with on their own. And so it would be useful, say, to have such a court in areas where the crime families and drugs and other and terrorism can be tried more or less locally. Now, I should mention another international court, but actually I forgot to mention among one of the courts, an ad hoc court, criminal court that sits in The Hague at the moment, is the one that is trying former President Taylor of Liberia for crimes committed during his rule in Liberia and in other countries. While he's being tried by the Sierra Leone Special Tribunal, but that tribunal decided that it was safer to try him in The Hague. So you've already heard that there are 3 courts, and I'll give you a 4th one that sits in The Hague. That's a court that has been in existence for almost 30 years. And when you hear it's the U.S.-Iran Tribunal. It was created to settle trade and financial disputes between the United States and Iranian citizens, between the U.S. and Iranian citizens, and also between the government, that arose as a result of the seizure of the American hostages and the embassy. Now, this tribunal, believe it or not, continues to award damages in large amounts to the respective governments and private companies of both states. Not only continues to award it, but the people are getting the money. These monies were put into escrow by both countries to ensure that the money would be there. What is striking about it is that despite all the problems that exist between Iran and the United States, and when you hear our politicians speak about it, you'd never know that there is such a court that is working. It's composed of 3 Iranian judges, 3 American judges, and 3 neutral judges. And the only problem they ever had was at one point, which is a wonderful story, I heard it being told by one of the American judges, was that at one point early on, a fist fight broke out where two Iranian judges were beating up the neutral chairman. But that issue was settled, and he survived. So you can see it's interesting to serve on international courts. You wouldn't have thought so. Now, what we tend to forget is that prior to the Second World War, only two international courts existed. And that's not all that long ago. Some of us still here who lived through the Second World War. The first ever international court, again, believe it or not, was the Central American Court of Justice. Just as 5 Central American countries. Unfortunately, it only lasted for 10 years. It was established at the turn of the century and didn't survive the First World War. The other was the Permanent Court of International Justice. It was established by the League of Nations, began to work in The Hague, where we sit, in 1922. And the ICJ, the International Court of Justice, is the successor court to the Permanent Court of International Justice. So we use all of their precedent cases. If you come into our offices, you will see their decisions and our decisions on our shelves. We cite them as our decision. In that sense, our court is now in existence for about 90 years. Now, the fact that so many new international courts have been created since the Second World War indicates, to me at least, that states today are much more aware of the needs to resolve their dispute by judicial means, and that these old-fashioned notions of state sovereignty tend less and less to prevent recourse to international courts. And of course, there's probably a greater need for these courts today than there may have been, or at least a greater perceived needs for these courts than there used to be before the Second World War. Now, in addition, there exist a large number of arbitral tribunals. These are not, strictly speaking, international courts that apply international law, but they resolve commercial and investment disputes between states and private parties. For example, the World Bank has established an arbitral facility known as ICSID, International Center for Settlement of Investment Disputes. And the reason that was set up was that many investors from wealthy developed countries didn't want to invest money in developing countries if there was a risk that if a dispute arose, that they would have to take their dispute to local courts, because they figured they wouldn't get justice in local courts, especially if the government was one of the parties to this dispute. So there was tremendous pressure to establish systems where if you wanted to bring in investment, you had to agree to bypass your court and have panels of arbitrators established. What is interesting about it, I am on one of the lists for ICSID. What is interesting is that you find now that more and more developed countries are being sued for violation of investment, and sometimes even by developing countries or by companies from developing countries. So while it was first created as something that was just going to be used against developing countries, it's no longer the case. And now some countries, developed countries, are trying to figure out some ways to escape these mechanisms. This, again, it shows you that the system is working. There's also, finally, in just enumerating courts that most of us don't know anything about unless you've sat on one of those courts, and those are international administrative tribunals. You probably know that if you're working for an public international law organization, and if you have a problem with a work contract or with you think you're being discriminated against, you cannot sue in local courts because the institutions have immunity from suit. But, so in order to deal with this problem, and there are real issues that arise, they've established administrative tribunals within the organization to which you can bring cases. And the judges on these administrative tribunals, I sat on one dealing with the Inter-American Development Bank. The judges are selected from different parts of the world to sit on those tribunals. The result is, and there's an administrative tribunal for the UN, for the International Labour Organization that gets a lot of other countries, for the World Bank, for IMF, the Organization of American States, and so forth. What is interesting about these courts, and those of you who are looking for topics in international law, they've created a tremendous amount of international labor law, employment law, things that most people don't know anything about because it's not a sexy thing, but it's interesting stuff that there's some very interesting discrimination issues that arise. You've already been told about the U.S. reluctance to join international courts. But what is striking about the dramatic increase in the number of international courts is that with the exception of the International Court of Justice and the World Trade Body and the World Trade Organization, the U.S. has not accepted the jurisdiction of any of these many tribunals. And as a matter of fact, when it comes to the International Court of Justice, the U.S. has only accepted a very narrow basis of jurisdiction. There are lots of international treaties by which the U.S. is bound, and they provide for our jurisdiction. But the U.S. actually withdrew its acceptance of jurisdiction many years ago in a dispute with Nicaragua. Now, I think I mentioned already that there are 27 states parties to the Court of Justice of the European Union. The U.S. is obviously not a party. There are 46 countries parties to the European Convention of Human Rights. And these states thus can be sued in that court. There are now 106, and there may be even more, but my last count, 106 nations have ratified the statute of the International Criminal Court, not the United States. Actually, President Clinton, on his way out, signed the statute establishing the International Criminal Court, but the Bush administration withdrew his signature. A very large number of states is also a party to the UN Law of the Sea Treaty. The UN Convention on the Law of the Sea is of tremendous interest, potential interest to the United States. But because of some senators who oppose it, we still haven't been able to ratify, even though the U.S. Navy and others see it as an extremely important treaty to be part of. All Latin American countries and some Commonwealth Caribbean countries have ratified the American Convention of Human Rights and accepted the jurisdiction of the court, and that amounts to close to 30 countries. Now, while most people in Europe and in Latin America, for example, know about international courts and strongly support their country's membership in them, few Americans know anything about them. And even some American judges and members of Congress have taken the position in the last few years that U.S. courts shouldn't even cite to cases of international courts, or for that matter, foreign courts, even though they're dealing with similar issues. Nobody said that they should take them as binding precedent, but just to cite them, because we share common problems as judges. As a result, the U.S. increasingly plays a very limited role in the development of international law, which, after all, is part of our own law, which we also forget. Moreover, by not participating in the lawmaking process, the U.S. is prevented from influencing the manner in which this law develops, if only because American lawyers do not serve on these courts, even though Americans and our economy is increasingly affected by these courts and by the decisions of these courts. Now, this is, in my opinion, sad, because international courts increasingly play a major role not only in resolving international disputes, but also in contributing to the development of international law in many fields that are of importance to the United States as a nation, to American companies, and in promoting the rule of law throughout the world, which is something to which this country has been committed for a long time. This also means, incidentally, and this is important to emphasize in an American law school, that American lawyers are deprived the professional opportunities that are available to lawyers from other countries and serving on and practicing before these courts. For example, if you, as a recent law school graduate, wanted to get a job at the International Criminal Court, you're going to have a hard time, because if you say you're an American, they'll say, well, your country isn't paying for the court. That's a good point to stop. Why don't you use the...
We're going to have a... Is this working? Says it's working. We're going to have a short question and answer session, and I think we have a student in the audience that's going to bring the microphone around. Oh, there you go, Brian. Okay, here are the rules. This is going to be a rule of law question period. Ryan is going to... Oh, okay. Ryan is going to give the microphone to the person that the judge or I call on, and then you're going to hand the microphone back to Ryan after your question so that everybody has a chance. So, who has a question for the judge? Michael.
Well, first of all, thank you so much. It's wonderful to have you here. I just have a brief question about the European Court of Human Rights. For that court to accept jurisdiction of the case, is it required that the plaintiff have exhausted the remedies in the country where the potential violation existed, or can a plaintiff from a European country go straight to that court?
No, they have to exhaust domestic remedies, unless it is totally clear that there are no domestic remedies available, which is rare. And if I were advising a plaintiff, potential plaintiff, I would say, get a ruling to that effect domestically before you go on.
So even a foreign national, hypothetically...
It doesn't matter. If you're a victim by one country that is party to the European Convention, you have standing to bring a suit, but you have to exhaust domestic remedies in the country.
Okay, thank you.
Another question? Over there? I'm making you move around.
My question actually does relate to the effect of international law on labor and employment issues, and insofar as the United States is not a party to, well, it hasn't really ratified many of the ILO conventions, even whenever it is a member state, and even though it has ratified some of them, it doesn't really live up to those standards. Why do you think it is that the United States has been so hesitant to actually protect labor rights and human rights in that perspective, or even really view it as a human rights issue when, say, looking at the case back in 2001, Hoffman plastic compounds? I'm not sure if you're familiar with that, where actually there was a denial of a remedy to a illegal immigrant who came into the country and apparently was trying to unionize, and because he was an illegal immigrant, the United States Supreme Court said the policy with our immigration laws overrides this. We can't give him a remedy. We can't sanction the employer in any way, but you can violate his right, even though the court had previously said that that person was an employee covered by the act. But there are many, many situations, I think, like workers' comp issues, where they'll be injured, and even though they're paying into the system, they're not receiving any benefits from Social Security or anything else whenever they're injured. Why do you think that the United States is generally like approaching issues like that as far as labor and migrant workers and everything?
Well, I can't say about the motives, but in terms of the U.S. not having ratified many of the ILO conventions, the reason for it in the past was always the argument that because of our federal system, we couldn't commit ourselves to complying fully with the ILO conventions, or for that matter, with ILO recommendations. You know that the ILO not only adopts conventions, that is to say treaties, but also has recommendations. And that was the argument. But there are other countries that have federal systems that have been able to deal with the issue in the past. And many of these ILO conventions even have so-called federal state clauses that prevent federal states to adjust their compliance. But it's been very hard in the United States for a long time to bring about ratification, not only of labor convention, but human rights convention. The argument of the federal argument has always been made. In the past, racism was also an issue as far as the ratification of convention was concerned. There was, especially when we still had de jure racial discrimination, there was a serious problem to ratify, say, a convention like the UN Racial Convention. We have ratified it. We've ratified the UN Covenant on Civil and Political Rights and the Torture Convention. But we've also done it often with very extensive reservations. But at least we've done it more so than in the past. And it's took a long time pushing to get it ratified, and I hope that sooner or later we will withdraw some of these unnecessary reservations and declarations and understanding we've developed. If you take U.S. constitutional law these days and international relations, you learn about all these details. What is the difference between a declaration, an understanding, a ratification? All of these things we've created that other countries seem to be able to not need to comply with human rights treaties. For example, Germany, France, and some other countries that are not that different from us. I should take the closer one. Well.
Thank you so much for being here today. It's a great honor. I just had a question about the ICC. I was wondering what remedies, what penalties the court can impose upon leaders and generals and officials who commit atrocities like genocide in different areas of the world, and how do they get these people before the court? How do they capture them, and who has the jurisdiction to do that? Thank you.
Mm-hmm. Well, first of all, they can impose penalties up to life imprisonment. There is an understanding today that no international court can impose the death penalty. So that's point number one. As far as catching them, that's not always easy. For example, it'll be interesting to see how the president of the Sudan is going to be brought to The Hague. But sometimes strange things happen because people are deposed, and then their own government may turn them over. And also what has happened is that some governments, and there's one such case, there's somebody there now from the Congo who's basically been turned over by his own government. So that can happen. Also, today more and more people are afraid to travel, those type of people, because there are extradition requests through Interpol. So they come to the border and suddenly they're arrested. This happened recently with the protocol officer of the Congo, who was arrested in Germany, wanted for crimes in, not the Congo, Rwanda, for crimes that were committed there. So that's the way it's happening. And I think you're going to see more and more. Many of these dictators don't last all that long. And they're beginning to worry about traveling. So that's nice.
What do you think can be done to get better enforcement of international law? Because in a lot of instances, like with the United States, or you've got an ally, a dictatorship or a powerful country that's an ally of the United States that won't. There's a kind of a potential to ignore the problem. Or with the case of Nicaragua, for example, with the Sandinistas in Nicaragua, the United States just simply ignored the court's ruling. What do you think can be done?
Well, people like you doing something about it. I'm telling you what is happening. Well, what is interesting, you take the Nicaragua case where we decided to withdraw before it was finished, which was a mistake even from a litigation point of view. But there have been only, in the history of my court now, there have only been 4 of, at most, if you count, depending how you count, 5 cases of non-compliance with a judgment of the court. All others, there's compliance. Because when a state decides to accept our jurisdiction, they make a political decision that they may lose a case or win one, and that it will be much too costly for them if they don't comply with the judgment. Now, on the other hand, if you get a country like the United States, which has the veto power in the Security Council, and the Security Council has the power to enforce our judgment, but not over a veto of one of the 5 permanent members. So one way would be to provide initially that there be no veto when it comes to the enforcement of judgments of our court. But your question is much broader, and it really is a question of socializing governments and countries to the need for compliance with international law and the advantage that there is. For example, we were just talking on the way over. Many European countries decided to ratify the European Convention on Human Rights, even though they have some bad human rights records. Why? Because they saw that as a way to get into the European Union. So they have to have these incentives. States, like human beings, are governed by, move often by incentives. So we have to develop some of these. But compliance, in many ways, is much better now than it has ever been. We just have to push more. And all of this has been in existence for less than 50 years. So we're moving. I see this, I'm always being accused of being an optimist.
Thank you, Your Honor, for coming today. I was just going to ask you, for those of us who are very interested in these topics but don't plan to go into it as our primary field straight out of law school, what are some ways to stay involved and stay up to date, and then maybe later on in our careers hopefully volunteer our services, whether to national governments or international organizations?
Well, it's a very good question, because they are, unlike in my day when I was in your position, there are many NGOs today that take cases involving human rights and international law. And many law firms do pro bono work in it. So even if you are in private practice that is not connected with anything, there are opportunities for doing some work in the field with an NGO, assisting in some ways. That's one way. And quite a number of lawyers do that. Also through the ABA, which has quite a number of groups where it's important for lawyers to participate, because the ABA has a lot of political influence. And it was the ABA, really, in many ways, that managed to get the U.S. to ratify some of the treaties I mentioned before. So participating in the ABA and some other bar associations that do international work, all of them today have international committees, is very important. And before you know it, you're in with a lot of other people, and you'll be used and abused.
I want to interject a question, because I think at least members of the federal courts class may be in attendance today. And I was hoping you could address the tension between federalism in a very important country like the United States and international law. Using as an example, perhaps, the Mexico case, which the court just decided, where there's an obvious tension in enforcement because of the limited powers of our central government, according to the Supreme Court.
Yes, no. Let me do that by reference to the case you mentioned. My court has had to decide a number of cases relating to or involving the application of what is known as the Vienna Convention on Consular Rights. And that convention provides that if you are a national of a country that has ratified this convention, if you travel to other countries and you're arrested, detained, you have a right to be informed that you can access your consul. And the consul can then provide you, depending upon the country, with whatever assistance you need. Well, in the United States, we've had a number of cases, but the latest one was one in which it turns out that there were 53 Mexicans on death row in the United States who were never informed in a timely manner of the right to access the Mexican consulate. The Mexican consulate had developed all kinds of mechanisms to assist Mexicans who were arrested in the United States. Well, some of these people were under a threat of almost immediate execution. Mexico came to the court. We had jurisdiction because there's a protocol that to this convention that provided for the International Court of Justice to have jurisdiction in case of a dispute relating to the interpretation or application of this convention. And the U.S. came and argued the case. And we, in fact, examined the situation and found that except for 2 of these people, 51 of them never received the proper information that they were entitled to. And so we ordered the United States government to ensure that these individuals would be given review and reconsideration of their conviction and sentence to see whether or not they were prejudiced by the denial of the information to which they were entitled. Some U.S. states, I think it was Oklahoma or Arizona, one of those, immediately complied with our judgment on its own. Well, Texas decided that it wasn't. I should tell you that when President Bush was still governor of Texas, he once declared that Texas was not a party to the convention, and so consequently he didn't have to comply with it. It's interesting, he learned a lot later, and I'll explain to you why. Because when this case, well, we ordered all of these people not to be executed and to be given this information, and not to be executed until American courts found that they weren't prejudiced. Well, it then came to pass that in one of these cases there was an imminent threat of execution. The Mexicans came back to us in the case, in this method that I won't get into. In the meantime, the U.S. government, aware of the problem, which was a serious problem, this is now President Bush acting, decided, both the Justice Department and the State Department, to have the President, President Bush, issue a proclamation ordering the states to comply with our judgment, which was unprecedented in many ways and very important. Texas said he didn't have the power to do that. See what happens when you leave to be a governor, become president? You don't have the power. So Texas went to the Supreme Court of the United States to challenge the authority of the president, and they won. And then Texas, despite the letter from the Secretary of State, a joint letter from the Secretary of State and the Attorney General to the governor of Texas, urging him to wait till the court had an opportunity to deal with this matter, proceeded to execute the person. And now put yourself in the position of the American judge on the court. That's federalism. So it's a problem. At the same time, of course, the fact that let me put it another way. I tried in my 9 years on the court to try to explain to some of my colleagues what it is to be in a federal system. And they've never understood it, especially those who come from a system that is not federal. And once I even invited Justice Breyer to come, and we had no case involving the U.S., to come and talk to us, and then, of course, they asked about the federal system. And he explained it beautifully. And I thought, oh, finally they understand it. 2 days later, one of them asked me again, how does this system really work? So and I always say that I learned more criminal procedure in my court, U.S. criminal procedure, than I ever knew, because I had to continuously explain. It's not easy to explain. And, of course, Texas acted, in my opinion, in a totally irresponsible way in terms of getting the United States to have violated an international treaty when they could have waited just a few months before the court decided the case. But they just went ahead, to hell with it all. And it's not the question, here it's the question that Texas simply shows no respect for its own government.
Next.
With such things happening in the United States, I was wondering if there have been any hopeful signs from the new administration about whether the United States will start complying with some of the international law treaties and maybe subject themselves to jurisdiction in any of the international courts.
Well, I think it's a little bit too early at this stage. I haven't seen anything. I know that the American Society of International Law has established a very high-powered committee to try to get the U.S. to ratify the International Criminal Court statute. I don't think that's going to happen very fast. It'll take a long time to do that. And we don't, at this point, even have a legal advisor in the State Department yet. So it'll take a time. But I think I would expect some movement on some issues. But I'm not too optimistic on the International Criminal Court. It would require quite a big push. But hopefully something is going to happen. It's too early. I wish I could tell you more. I just don't see it happening. Certainly, the closure of Guantanamo and some of other measures are important in sort of signaling to the world that we are returning in many ways to being the country we were some time ago. I put this very delicately because I've lived the last 9 years abroad, and I can tell you, especially when you're an immigrant, you feel for the country probably more than you guys who were born here, and it was just natural. And when you see that the standing of the country just goes down and down, down, it's painful to see, and this is what was happening in the last few years. And so I hope that we're going to see a return to where the U.S. was before. I'll just give you one example. After September 11, the Queen of the Netherlands gave the speech from the throne. It's every year about this time. It's usually a very happy occasion. The whole diplomatic community goes, and there are parties afterwards and so forth. She instructed everybody to appear in black. There was no celebration, nothing, and she only spoke about the United States and this terrible thing that happened to the United States. On the street on which we live, people know we come from the U.S. People would come over, express condolences. Then things happen. And then when you were at a party, for example, and you were asked, who are you, what are you doing? And you would say, well, I'm the American judge on the ICJ. You'd get this gymnastics that were being played, trying to figure out where you stand, whether you support this government or not. I mean, all of the type of things that it was so sad to see happen, and in many ways unnecessary. I see a very big change, and the expectation in Europe is such, at least the area where I know, that I hope very much that we can again start playing the important role that this country played in promoting human rights. Historically, we were in the forefront of all of these instruments and promoting all of this. So I hope it'll happen, and not just the Democratic administration, but whatever follows, that we will do what this country can do and should historically do.
We have time for one or two more questions, so raise your hands. And before the next question comes, I wanted to, whoever, you choose. I wanted to mention one thing that I forgot. Since the judge mentioned how he is an American by choice, not an American by birth, it reminded me that his most recent work is a book not on law, but a book on his experiences during and after the Holocaust, escaping as a refugee and coming to the United States, called Lucky Child, which has been published in Europe and is about to be published in the United States, which I'm sure our library will order. Okay, April 9th, it's due out. So if you want to read very readable, non-legal writing on behalf of Judge Buergenthal, look out for Lucky Child. And the next question.
But before you ask the question, let me just say something. It's a strange experience for somebody who's written law books that nobody ever asked him to read, to suddenly find that you have a book that people want you to read from.
Yes, I have two questions relating to international family law.
We'll ask one, so somebody else gets a chance to ask another.
Okay, then I'll ask one. And, so I'll ask the one dealing with the area of private international law. At the end of your lecture, you spoke generally on the possibility of American citizens practicing abroad under some of these treaties. And I've personally become recently interested in the 1980 Hague Convention on parental child abduction. And being someone who is an American citizen but is proficient in the German language, I was wondering if the only way to actually practice, either whether it be in the trial courts of Germany or eventually in the European Court of Human Rights, is to pursue some kind of dual citizenship, or if there's any other bar that one can be a member of.
Well, let me first tell you, I cannot give you an answer that I would consider correct. My first question to you would be, could you claim a double citizenship from a country of the European Union?
I'm currently engaged with the German national.
You have to hurry. And I think citizens of European Union countries can practice in other states, provided they have the sort of professional qualifications. I don't know how it would work in Germany. Some of the countries in Europe provide for reciprocity, and that is to say, if their lawyers could practice in the United States, you could practice there. The problem in the U.S., with the U.S. of always establishing reciprocity isn't all that easy. But in the U.S., you as a foreign national, if you were one, could take the bar and, in fact, in some states in New York and some other states, be admitted to the bar. And so there would be reciprocity. And what you need to look at is there a country in Europe where there is reciprocity, a European Union country? If you get into one of those, you can then move to the other one. So you have to do some good lawyering for yourself.
One last question.
This is a follow-up to your discussion of the Medellin case. I'd heard that whenever Medellin was going to be executed soon, that Mexico had actually came back to the ICJ and asked you all to give a provisional measure or to make some sort of ruling on the case, and that Mexico or that the International Court of Justice had won a ruling and said that they needed to do let me read my notes. The ICJ had dismissed most of the arguments that Mexico had made, saying that they needed to that Mexico had some sort of ruling over this case and that ICJ needed to do something. Do you know, is there anything that the ICJ could have done to have forced the U.S. to have stopped the execution, and would they have any kind of claim to enforce action in that case?
Actually, what happened was that when the execution of Medellin approached, Mexico came up with a very ingenious legal argument to get the case back to us. And the argument was that they wanted to have an interpretation of our original judgment in that case, the Avina judgment. Medellin was one of the 50 who are covered by the Avina judgment. They wanted an interpretation. And they asked us, in connection with the interpretation request, to issue provisional measures, which is a temporary injunction. Because at this point, we no longer had jurisdiction of the United States, except for the possibility of proceeding by means of an interpretation of the original judgment. We granted the provisional measures. We then we then opened it up to argument by Mexico on whether or not there was a valid basis for provisional measures, for an interpretation. And we held just very recently that there was that Mexico's attempt to obtain an interpretation was not justified. In the meantime, of course, Medellin had been executed. At the same time, we reminded the United States of its obligation to comply with the Avina judgment, because there's still 40-odd people sitting awaiting execution. At the same time, we also held that even though our provisional measure was improvidently granted, nevertheless, the United States violated the provisional measures, the injunction, by executing him before we could deal with the case. So that was a very recent decision of our court. So Mexico won, at least in the sense that they got another statement from us that the U.S. had an obligation, which of course the U.S. knew. I should tell you that there is a bill pending in Congress which was introduced before, and maybe that bill, that goes back to your question, maybe that bill will get through, and it would provide for the enforcement of our decisions, possibly modeled on the way in which the U.S. enforces judgments of the World Trade Court. That's the answer.
Thank you. Okay, a couple of announcements before we give our final thank you to the judge. At 3 p.m. today, our Jessup Moot Court team is going to be doing one of their final practices before heading off to Washington for the Jessup International Moot Court round. And very ironically, they're going to get to do a practice in front of a real-world court judge before this weekend they do the real round before fake world court judges. So any of you that want to see that and see the judge in action, that will be 3 o'clock today in this room. Also, I know a few of you still have your hands up. If you're folks in this building, I will try to ask the judge if he'll be available up here for a few minutes before the Jessup round starts if you have any further questions for him. Finally, there are a few media people here. We're going to make the judge available in the judge's chambers for a couple minutes right after this if any of the media people want to have a few moments with him. And other than that, thank you all for coming, and thank you very much, Judge. That was fine. It was wonderful. Going longer. You went exactly about a half an hour. Our introductory speeches.